Good afternoon to everyone. Thank you for joining us. And I will moderate the panel on the legal dimensions. We have three expert panelists, but before introducing them, I want to tell you what did we ask them to talk about. So we have 4 questions that they were asked to refer to. The first, to what extent is this ICC investigation on the situation in Palestine purely a legal matter? The second is, what are its legal implications? The third, what legal tools are available for coping with the challenge? And the fourth, should Israel cooperate with the investigation? So these are the questions, and now who are going to give us the answers? So we have 3 distinguished panelists. The first will be Ambassador François Zimeray, and I hope I pronounced the name correctly. Ambassador François Zimeray is a former member of the European Parliament, French ambassador to Denmark, and French ambassador at large for human rights. He has specialized in both international commercial and international human rights law, and is an expert also on international criminal law. Then we will have Dr. Christophe Eick. What is the right name, pronunciation? Eick, sorry for that. Dr. Christophe Eick is the Director General for Legal Affairs and the legal advisor of the German Federal Foreign Office in Berlin. And finally, we have our legal advisor, Dr. Tal Becker, who is the legal advisor of the Israeli Ministry of Foreign Affairs. So each of you gentlemen have 5 minutes to make opening comments. I will, I will be the bad guy this time, and bad girl. And then we will open it up for discussion. And in the end, we will have some time for short comments, short concluding comments. So please let us start with Ambassador Zimeray, please. So the screen is yours.
Yeah.
You need to unmute him.
Yes, sorry. I was saying merci beaucoup, which means thank you very much. It's a privilege for me to be with you today and to find again some old friends such as Irvin Kotler. And I have to say that I agree with a lot of things that I have heard. And I will try to not to be the bad guy, because we already have a bad guy, I understand. But I try to be to be a little the devil's advocate, or to bring some nuances, not to contradict everything which has been said, but to bring some nuances. I think that's very, very important. The question for me at this stage is not to express an opinion about if this decision of ICC prosecutor is fair or unfair. My question is, how should we look at ICC as friends of Israel? And how should we invite Israelis to look at ICC? And I'll try to answer the very precise question you have raised in your introduction. First, I have to underline, as it has been done by Irvin Kotler and other persons, I have to underline the very intimate link which exists between international justice and the history of the Jewish people, and especially the history of Israel. I do think that Israel has invented international justice, because when you go in Argentina to capture a German officer and to judge him in Israel for crimes committed in Poland, what is it if not the invention of international justice? And I'm also grateful to those who have pronounced the name of Raphael Lemkin. The suffering of the Jewish people, from Lemkin and the Genocide Convention to the Nuremberg trial, and then to the Eichmann trial, the suffering of and the tragedies of the Jewish people are a large part of the grounds of this concept of international justice. And I have always considered as an anomaly the fact that Israel was always reluctant to join this court from its origin. As you asked us some very precise questions, and as we are between lawyers, we have to bring precise answers. What are we talking about? Are we talking about a condemnation of Israel? No. Are we talking about an indictment of Israel? No. The point we are discussing is to know if an inquiry should be open or not. It's not condemnation, it's not indictment. We are talking about the opening of an inquiry after a tragedy, a war, which made hundreds of civilian deaths. And this inquiry, is it targeting especially the Israelis? No. This inquiry targets or embraces offenses or crimes that could have been committed by Israelis or Palestinians. And this is a premiere in this environment. Are we talking about a procedure against the state, and especially against the state of Israel? No. ICC is not competent to judge state. And that's important because non-lawyers are listening to us. ICC is competent only to judge persons, people, and not states. And that's very important because you put the finger on the question of how politicized it could be. And I think one should not politicize the case more than it could be already. I'm not naive, and I know that there is an intimate link between politics and international state of law. Sometimes that's for the best. The very legitimacy of Israel relies on a deliberation of the UN General Assembly, which has been adopted. It's a political decision. It found the political and legal legitimacy of Israel in international law. So of course there are some links, and it would be very naive to put aside the fact that we are in a region of law which is very close to politics. It doesn't mean that this decision to open an inquiry should not be welcome. And of course, we will elaborate later in the debate. I will stop because I'm afraid, and I will just conclude to say that, yes, it's really shocking and counterintuitive, especially for non-lawyers, to see that after Syrian crimes or what's happening in China and in many places in the world, ICC cannot open inquiry. It's not that ICC doesn't want. It's simply that legally it's impossible because too many countries, especially Arab countries, plus China, plus Russia, plus United States, plus Israel, have not adopted and joined the Rome status. But to phrase it in one last sentence, I would say that I'm not saying that ICC is perfect. I think that one should reject and condemn potential deficiencies or failures of ICC in the name of ICC values. But one should not reject and condemn ICC in the name of its potential deficiencies and failures.
Thank you. Thank you very much, Ambassador Zimeray. And now we turn to Dr. Christophe Eick. Eick, please, the floor is yours.
inviting me to this panel. I would like to thank the conveners of today's roundtable for the invitation, and to thank Aria Benzemoun, Chief Executive Officer of ELNet France, for his opening remarks, and Erwin Kottler and Justice Rubinstein for their insightful and inspiring keynote speeches. And I may say that Professor Kottler perhaps does not remember, but I was one of his students at McGill some 35 years ago, and I have very fond memories of that time. And I'm looking forward, of course, to our discussions and to this question and questions and comments from the audience. As the first panel will deal with the legal implications of the ICC's engagement in the situation in Palestine, I should like to take the opportunity to outline first Germany's position on the territorial jurisdiction of the ICC as recorded in our amicus curiae brief we filed with the court and upon the court's request in the spring of 2020. And second, to provide you with some background on our motivation to do so. And I would then, in a third step, also say a few words on our understanding of the pretrial chamber's decision of February 2021 and on the way ahead. Amicus curiae, as you know, literally translate as friends of the court. And Germany is indeed an outspoken supporter of the International Criminal Court. Hence, when the court in its order of 18 January 2020 invited states to provide written observations on the prosecutor's request for a ruling on the court's territorial jurisdiction in Palestine, Germany accepted this invitation.
Dr. Eick, we have an issue with your, we can't hear you.
Okay, is that better now?
Yes.
Okay, sorry. I was just referring to our amicus curiae brief we filed with the court, and explaining that the court may, of course, exercise jurisdiction if the state on the territory of which the conduct in question occurred is as party to the statute. We considered that Palestine could not qualify as state in this regard, which then, in our view, barred the ICC from exercising jurisdiction. And we highlighted three main points. First, Palestine's so-called instrument of accession to the Rome Statute of 2015 was not determinative for Palestine meeting the criteria of statehood as required under the Rome Statute. The instrument had been circulated by the Secretary General of the UN as the depository of the Rome Statute. However, the circulation by the Secretary General had not implied a legal ruling on Palestine's statehood or accession to the Rome Statute, but amounted to a mere technical administrative act. Second, the court, in our view, had to confirm Palestinian statehood in accordance with the relevant criteria under general international law. From our point of view, adopting a case-specific application of the traditional statehood criteria under international law for the purpose of the Rome Statute appeared and appears problematic. And Professor Kottler has already referred to the Montevideo Convention on the Rights and Duties of States that sets out the constituent criteria of statehood that have been generally recognized as customary international law, and in our view, and of argument was that Palestine.
Dr. Eick, we're losing you again. We're losing you again.
Maybe you can put off the camera, maybe, so we can hear better.
Okay.
Now we hear you again, I think. Try
Okay.
it. Yes,
Now
it works.
the line is not stable. So maybe if you put off the camera, then usually we'll be able to hear better and without seeing you, unfortunately.
All right, perhaps it's better now.
Yes.
Yes.
Let's try now. Okay, so this argument state that
Dr. Eick, I'm sorry, but the line is really bad.
Sorry, Dr. Eick, we can't hear you. Is there any way that you can maybe try to do something on your end, and maybe then we can move to Dr. Tal Becker and come back to you? Is there anything that can be done with the line, because it's very it's difficult to hear him.
Okay, I will see what I can do, and perhaps if you give me the opportunity, come back after my friend Tal Becker, that would be great. Okay,
thank you, and sorry for that. So without further ado, and since we want to leave enough time for the discussion, so Tal, Dr. Becker, over to you.
Thank you, Pnina. I hope you can hear me, and thank you to Elnet for organizing this. A pleasure to be with all of you, Professor Kotler, of course, and Justice Rubinstein, and my colleague Christophe as well. Lovely to see you, and I appreciated the comments of Ambassador Zimeray as well. Pnina, you've given us a difficult task in 5 minutes to answer 4 questions. It might be beyond my abilities, and some of them I don't want to answer, which makes it even trickier. I do want to begin by saying a comment that has been made by others, that I think the Jewish people, given their history, and Israel, given its its values and aspirations, cannot but want for the success of the International Criminal Court and its goals. And I think over the years, the commitment of Israeli and Jewish lawyers to this cause, as was mentioned by others, has demonstrated that. And I think our reaction in particular to the way this situation has been dealt with shouldn't be read as opposition to the goals of the International Criminal Court, but yes, as very, very grave reservations and concerns about the way in practice the International Court has operated and is implementing the Rome Statute. You asked, to what extent is it purely a legal matter? So I want to be a little bit less diplomatic here and say that, you know, it's very common in legal arguments for us to attribute to the side we disagree with non-legal motivations and present our own position as if it is, you know, the pure articulation of the law, and the contrary position as if it has some other motivations. So I think that that's a claim that shouldn't be made too easily. And I want to perhaps mention a couple of reasons why there is real concern that in this particular case, the arguments used to make the case for jurisdiction and enable the situation to proceed to an investigation stage raise real questions about the degree to which it was driven by legal considerations. First, let me say something a little bit non-loyally. The prosecutor's request under Article 19.3 for jurisdiction ran about 110 pages. In other words, it took about 110 pages to make the argument for jurisdiction. Now, if you're a criminal prosecutor and you haven't even begun a criminal process, but you want to just make sure that you have jurisdiction, you might be a little worried if it takes 110 pages to make the argument that you in fact have jurisdiction. And I think in a way, almost symbolically, this is already a warning sign. In fact, to make the case for jurisdiction, you need an accumulation of a number of very difficult arguments. You must argue essentially either that Palestine is a state or that it doesn't need to be a state for the court to have jurisdiction, both of which are very controversial and difficult arguments to make. Then you need to make an argument about the territory of that entity, when that territory is clearly a matter that is not yet decided or undetermined, a very difficult second argument to make. And then you need to explain why the Oslo agreements, which very specifically deny from the Palestinian Authority the very criminal jurisdiction that they are purporting to delegate to the court, don't matter in this consequence. Those minimal arguments. And what happens, I think, in the case for jurisdiction is that you need an accumulation of very, very controversial, shaky arguments to make your case. And when you do those 3 in a row, it raises a question whether what was involved here was genuinely a kind of mainstream, dispassionate analysis of legal principle. I think if you look at the majority decision, and particularly when you look at the majority decision in light of the devastating dissenting opinion by the presiding judge, Judge Kovac, you see here also real questions about how did they get to their conclusion. One of the most striking elements of the dissenting opinion is that he points out how the majority judges had to misquote a key provision of the Rome Statute, Article 12.2, in order to make the case that for some reason in this case, Palestine doesn't need to be a state under international law for the Cape to have jurisdiction. And we have also, for example, an unprecedented reliance on contested, non-binding General Assembly resolutions to make a claim about territory, when in previous jurisprudence of the court, the phrase territory in the ICC statute was understood to mean sovereign territory. And all of a sudden, the judges here say, we don't need to do that. Now, in my job as the legal advisor of the Foreign Ministry of Israel, sometimes we're very careful to see when we are accused of, when countries talk about applying international law, whether it's in fact what we're being told is law and whether it's international. In other words, is it actually the law? And here I think there are real questions about the analysis. And second, is it international in the sense that it's the same standard being applied to other countries? And we have seen in the approach of the prosecutor, the attitude generally was that the term state meant state under international law. The prosecutor speaks of the sovereign capacity to prosecute. And yet in this situation, the court tried a different argument because that argument didn't work or was more difficult. We've seen territory refer to sovereign territory. And yet in this case, they decided to rely on a political resolution to reach a legal conclusion. So whenever that happens, you need to ask the question, is there something other than a legal analysis going on, or is there perhaps some motivated reasoning and there is real concern? I'll mention two other points about that briefly.
Wait, no, Tal, I will stop you here and keep those points in mind. We still have the discussion and turn it back to Dr. Eick. I hope now we will be able to hear you just to finish the your opening statement, and then we will open it up to discussion. So you will all still have the opportunity to raise further points. So please, Dr. Eick.
Okay, thank you very much. I hope it's you can hear me now better.
Much better.
And I would like to just very briefly say a couple of things on what this decision actually means for the process ahead. Since I can agree almost entirely with what Tal Becker has said on the legal analysis of the decision, that, and you have I'm sure read my foreign minister's statement on the decision, where he reiterated our position, and at the same time, of course, said that we, as members of the Rome Statute, are respective of in respect of the court's decision. But what are the steps ahead? Now the prosecutor has decided that she will be opening an investigation, but as we all know, in 2 months' time, she will be ending her mandate, and we will have a new prosecutor. Of course, we do not know how the new prosecutor will handle this situation and other situations, and naturally we will not be in a position to comment on this. But we may have a new situation. Now I have taken note that Israel has reacted to the decision, and a letter by the prosecutor that was sent to Israel and to member states. Israel has reaffirmed its willingness and its ability to conduct national proceedings for alleged crimes committed by Israeli nationals. And we've heard Mr. Rubinstein earlier point out to the precedents that exists in in Israel. And I think this is a good move. This is a good declaration, and I'm sure that the ICC will take note of this because it touches on the cardinal principle of complementarity, the court being a court of last resort, only acting when national jurisdictions are unwilling or unable to conduct prosecution for those crimes. And I will end with this, and thank you very much for giving me the floor again. I'm looking forward to comments and questions.
Okay, thank you very much. And so now we will turn to the discussion, and I'm asking here, Pascaline, do we have any questions? So if not, so let me kick off with my question to Ambassador Zimeray. Your main point about trusting this, I think the issue was, or the main, to trust the system, to give it a chance, to believe in it, and I think that Tal raised issues and other speakers also about, I think, a fear, or I would say some kind of lack of trust, or at least a fear that we cannot really trust the system. And they were given all kinds of examples of steps that were done with the victims, for example, initiating an approach to the victims when there's no investigation. The flotilla case, we didn't mention it here, where the court insisted that it's severe even when the prosecutors thought it was not, and it was a case of exchange of fire. And here also the prosecutor's position that they clearly already portrayed the Palestinians as the victims and Israel as the oppressor already in her initial approach to the court. So don't you think that there is some ground to fear that Israel will not actually receive, or Israelis, okay, will not receive a fair trial in the ICC? You're muted, so.
Sorry, I know this fear, which is much more than a feeling. And this fear doesn't apply only on ICC. You know, when I was member of the European Parliament during the Second Intifada, I was the one who called for an inquiry committee on EU funding on Palestinian textbooks on Palestinian authorities in cash, whilst bombings and attacks were every day in Israel. When I was French ambassador for human rights, I was co-heading the French delegation to Durban II, and we decided to stand up when Ahmadinejad started to deny and to elaborate on the Shoah, followed by dozens of delegations. I know this environment. I know where this fear takes root, and it can be very legitimate in some UN milieu. I think it's much less legitimate for ICC. And this is on what I want to answer briefly but in depth your question. We all agree on the fact that there is a strong link, philosophical link, between history of Israel and the Jewish people and the very notion of international justice. I personally add that I consider that the fact that Israel is not part of this adventure of humanity is an anomaly. ICC has been created in 2002. The war and the events we are talking about are from 2014, if I'm not misleading. So from this very origin, Israel decided not to be part of ICC. In French, it's a procès d'intention. So this is just food for thought. It's not based on facts. It's not based on biased. It's just a point, an attitude of Israel of méfiance since the very origin. the Judge Kovacs expressed a dissent opinion on a question which can be debated. I'm not saying that the decision was right. I'm not saying that there is no room for legal debate. There is always room, as a lawyer, I know that, for legal debate. I'm just asking and following, putting my feet in the my shoes and in Peter Kovacs once. Does the Judge Kovacs consider that ICC is not legitimate anymore? Has he decided to quit this institution? Did he say it's a biased one? Or no, not at all. He just considers that he has a decent opinion on that. So this is exactly what I say. I'm not saying they are right. I'm just saying there is a room for debate, and the place of Israel should not be to contest the very legitimacy of ICC, but to comfort it and to express what Israel has to express in this framework. Recently, 2 weeks ago, France was condemned and severely blamed by a UN report on our attitude in Mali. This UN report, after an inquiry committee, says that French officers might have committed war crimes. We contest this opinion firmly, without any reservation, but we do not contest the very legitimacy of this inquiry committee of the UN. This is the difference. And my last word, I admit this debate deserves more than politicization, more than, how do you say, caricature. One should admit that talking about ICC or any international justice organization, they all are, how do you say, startups. They all are new and embryos, and they all have to innovate, and sometimes to innovate in a very disturbing way for a legal brain, a legal mind. I give you 2 examples, and this would be my last word. We all are in favor, of course, we welcome retrospectively the Nuremberg trial, even though it could have been better, but anyway, Nuremberg trial, okay, we think that that's good for humanity, that a jurisdiction could be established to judge, but we also think that there is a very principle of non-retroactivity. The jurisdiction was set up after the crimes. So it's for legal brain, it's a monster. For us, it's a good thing, but it's a monster. Another monster, correct me if I'm wrong, when Eichmann has been judged and condemned in Israel, as far as I remember, Israel didn't have the death penalty. So Israel innovated at this time. So we have to admit that there is a kind, I would not say of politicization, but at least there is a room for creativity, which could open the way for politicization. But what I'm saying is not that Israel should be condemned. I'm not saying that Israeli soldiers have committed war crimes. I know the precautions taken. I just say that it's absolutely unfair and not a good attitude vis-à-vis the history for Israelis to condemn ICC instead of playing the rules of ICC. And I welcome the fact that Israel will, as Mr. Eick has just said, that Israel will play the rule of the game and say we are going, or we have investigated, or we are going to investigate by ourselves, because this principle of complementarity and subsidiarity is the very key of ICC.
Okay, thank you. And Dr. Becker, do you want to maybe answer, and then we will move on to other questions and the points just raised?
Maybe I'll try to say two brief comments. I think that, you know, it's interesting to note that the prosecutor made this request because she said that she needed judicial certainty about jurisdiction to move forward, that it wouldn't be right for her to invest the resources of the court in an investigation if jurisdiction could be contested down the line. And in fact, what we've seen in the majority's opinion is a failure to answer the very questions that the prosecutor said were necessary to answer for her to have certainty. They have said specifically that this is a response to jurisdiction for this phase only, that jurisdiction can be challenged later on, and most specifically that they are not addressing what is a cardinal issue, the issue of the Oslo Accords and what they have done to the issue of jurisdiction. So the very certainty the prosecutor asked for, she did not receive. In fact, she acknowledges that. She said that was necessary for her to move forward. And just a second factor with that, the prosecutor recently said that in the investigations in the situations with respect to Ukraine and Nigeria, though the conditions existed to open an investigation, it was inappropriate for her to do so at this stage because she was in a transition phase to a new prosecutor and because of the court's limited resources. So from an Israeli perspective, when you look at these two things, you asked for certainty. You quite clearly didn't get the certainty you asked for. In two other cases where there is no jurisdictional questions, you've decided not to proceed precipitously. But here you decide to proceed. This is precisely the kind of challenges that makes Israel ask whether we are dealing with a body that is operating according to the strict terms of the Rome Statute. And I think that is where, Professor Zimeray, we have a difference, because it's so important, particularly for a country like Israel that is so used to a double standard. The need to show that there isn't that double standard becomes all the more critical and important. And I think, in a way, you know, the second point I wanted to make, and I'm sorry, Pnina, I know that the stopwatch is running. It would be okay, in a way, if this was just about the International Criminal Court. There are enough issues there and important to improve them. There's a really very significant report about the need for reform of the ICC, prepared by none other than Judge Richard Goldstone, and a very really pointing to a lot of issues that need to be addressed for the court. And in a way, this situation is just a symptom of that. But this decision has real impact on the capacity of Israelis and Palestinians to talk to each other, on the capacity of creating a political dynamic which enables the two parties not to be polarized, but to engage with each other. So the very idea of criminalizing the conflict, of drawing us to a discussion in a foreign court based on very contentious jurisdictional arguments, has a real world impact, because it shrinks the space for the two parties to speak. And I think if those who care about both the Rome Statute and the peace process, both the success of the court and creating conditions for dialogue, need to worry about turning the volume up on the criminalization of this conflict in ways that pull the parties apart. And as we say in international law, hard cases make bad law. And it looks like there's a lot of bad law here in this situation.
Thank you, Tal, Dr. Becker. And now we have a question from Advocate Elizabeth Belicha from Switzerland, sorry. So please, the floor is yours.
Thank you. I just wanted to ask the panelists whether, assuming that any Israeli would be accused and indicted, could they raise the challenge of jurisdiction challenge, and would this be a good defense tool? I have noted that in paragraph 77 of the ruling, it says that an accused will always be entitled to raise a challenge under Article 19(2) of the Rome Statute. And so I was wondering whether this could be a good defense tool, and also if there is any precedent regarding this such procedure.
Thank you. Who wants to answer? So here, Dr. Eick.
Thank you very much. And this ties actually in with, I think what Tal Becker has said, that the prosecutor, in fact, did not get all the answers that she was looking for, and the certainty that she was asking the court to give her. And I suspect very much that should, I say very much, you know, should we have one day an accused in front of the ICC, I'm sure that all these questions that we are discussing here today will be will come up again and will have to be decided by the court. So I think there is a good argument that can be made, and this I say this also to what my colleagues on the panel have said on the issue of Israel continuing to engage with the court. You know, we've had very recently, 2 weeks ago, the decision by the Biden administration to re-engage with the court. They have not said that they will join the Rome Statute, but they have said that they would like to engage with all the actors and with the state parties on issues that they have with the court and on the reform process, which is very important. So, of course, it's not for me to give any advice to Israel, but we have welcomed the U.S. re-engagement with the court, and certainly would do the same with regard to Israel.
Thank you. We have another question. Jonathan Turner from the UK Lawyers for Israel. Where is Jonathan? Here. Now wait, we will unmute you. Okay, you can go. Go ahead, please.
Okay. Can people hear me?
Yes.
Yes. So I wanted to ask to what extent are judges at the International Criminal Court and also the prosecutor influenced by the assessments, the work, the input of their staff, and whether this is a concern for impartiality, and if so, how that can be addressed?
Thank you for the question. Maybe Ambassador Zimeray, but I don't see. Is he there on the? Don't see on my screen, which doesn't mean anything.
I'm here, but my camera doesn't work. I think.
Okay.
So your question is how to challenge the impartiality of judges?
The question was what is the impact of the staff working at the court on the decisions?
I would say it's like in all jurisdictions. You know, you have aides, you have attachés. That's true that in general, and this is another discussion, but I cannot put it aside. And I think that on this point, I will find a great consensus between us. One thing that I have found extremely disturbing when I was for 5 years heading French human rights in French Foreign Service as French ambassador for human rights is to see the divorce between the human rights ecosystem in general and the notion of anti-Semitism, and of course not talking about the support of Israel, but more general, the sympathy for the Jewish people and the attitude vis-à-vis anti-Semitism. It's like if it had disappeared from the radar, the mapping of the human rights violations. That said, so there is definitely a problem in the human rights ecosystem and milieu in general. Does that mean that it affects the credibility, of the of this jurisdiction more than any other panel in the world? I don't think so. Contrarily to a lot of UN and multilateral institutions, which are by definition extremely political, ICC is made of judges, and judges that are sent by countries, and that most of them are known as amongst the more independent and respectable persons. So there is no reason for me to consider that there is more biased in Fatou Bensouda's attitude than there is biased in the Israeli prosecutor against Netanyahu. I don't think that anyone thinks that he's anti-Israeli. I don't think that. I may be wrong, but I don't think that. Same for the International Court of Justice or the European Court of Human Rights. They are made of judges and not politicians, and they take their role very seriously.
Okay, thank you. Do we have any more questions? So I'll ask a question, and I would be happy to hear, especially from our European panelists here. Do you think if there is negotiation between Israel and the Palestinians that is going forward, and if it is apparent that these proceedings, that if there is an investigation in the ICC and it is making it difficult to proceed with negotiations, and I think there is such a risk that it will hamper any potential progress. Do you think it's something that could be considered under considerations of justice as a reason to stop the investigation, at least to suspend it? Dr. Eick.
Well, I mean, we have to see how the investigation is proceeding, and if it is proceeding. I think there are a lot of open questions, and I'm sure that the investigators will also be looking what is happening on the ground. But if you ask me as a lawyer, of course, there would be the possibility for the Security Council in such a situation to ask for to mandate a deferral of the situation. But I think from a practical point of view, I would really look at the actors at the ICC monitoring the situation on the ground.
Thank you. If we have no questions from the audience, so maybe I will allow the three of you to, and we're also coming to the end of our panel. So maybe if you have some concluding comments, so maybe we start with Dr. Becker, and then Dr. Eick, and then with Ambassador Zimeray. So just Tal, you're the first. Concluding thoughts, what should Israel do? What is Israel going to do? You could maybe tell us. Please, go ahead.
Okay, the last bit I won't tell you, but I'll start by simply saying that, you know, I sometimes hear the question of why does jurisdiction even matter? What difference does it make? Let the court just deal with this issue. And I think for lawyers, to the extent that we're speaking to non-lawyers here, it's worth saying that jurisdiction is the very idea that separates a political body from a judicial one. When a body works within its mandate, it is showing respect for a set of principles that apply to everyone. When it reaches beyond its mandate, it's acting in a political way. And I think if we go back to the original vision of the court, a court of last resort that was meant to deal with mass atrocities, that was complementary to national jurisdictions, you see how being drawn into this conflict on such controversial determinations is so far away from the original mandate of the court. If I could again be non-legal, I think this court was imagined as dealing with evil, not dealing with conflict. In other words, it was there to respond to the atrocities in the tradition of Nuremberg and Yugoslavia tribunals and so on. And what happens when a court gets drawn into conflicts in this way and has to manipulate its jurisdictional arguments to get there, is that we have both harm to the goals and the institution itself, which needs to build legitimacy. And it builds legitimacy by showing that it is working with the constraints that was put upon it, and that it isn't subject to kind of popularity contests by how many votes were in the General Assembly. It's not decided by a show of hands. It's decided by judges who apply the law. And we have, I think, beyond the challenge of the investigation to Israel, we have a challenge to the project of international criminal justice and advancing it slowly, gradually, so that it gains more legitimacy, so that more states can have faith in it, and it begins to take more control over the world, over world affairs. And then we have the impact on Israeli-Palestinian relations. So I think when looking at this case, those who care about the advance of international criminal justice, and those who care about the ICC, and those who care about Israeli-Palestinian relations need to be concerned by this overreach and ask what in fact we are advancing, other than exporting the conflict to yet another battlefield, which will be dangerous, I think, both for the relations between Israel and the Palestinians and for the ICC. Thank you.
Thank you, Tal. Now, Dr. Eick, please, your final comments.
Yes, thank you very much. And very, very briefly, again, I share very much the sentiments that were expressed by my friend Tal Becker. And you know, it was mentioned that the International Criminal Court, after 20 years basically of its existence, is embarking in a reform process. And I think that's where friends of the court, like Germany, states that are so much attached to the principle of the fight against impunity, are going to be engaged in. And I would very much welcome if the voice of Israel in this debate is being heard. I think what Tal Becker has said just now and others resonates with many friends of the court and within the court itself. Thank you very much.
Thank you. And finally, Ambassador Zimeray, and here I want to give you a more concrete task. What would you suggest that the ICC does, or the prosecutor, the new prosecutor, to ease the fears that you hear from the Israeli side? How do you think they could win out trust?
Yes, if I could sum up what I have just heard about the vision of ICC, I would say, why is this jurisdiction different to the other jurisdictions? And I think that's a feeling we all have. I think that the new prosecutor should understand the Israeli mentality, which I will try to rephrase as I understand it, and I'm not Israeli. I'm always surprised to see that the Israelis, they often say, the world doesn't understand us, the world doesn't like us, and we will never change that. And I think that's very rooted in the minds, for obvious reasons. The world doesn't understand us. I have to say that after having been very much involved in the multilateral ecosystem, it's not false, it's true. The world doesn't like us. It has not been always true. Once upon a time, Israel was extremely popular. And when the first Israeli tourists came in the souk of Cairo, they were welcomed as friends, family, and cousins. Same today in the Gulf. And the third thing, we will never change that. I think that this is the problem. And one has to be two to tango. And he should speak, find the words, find the attitude to express the Israelis that this could change, that they are legitimate, that the very legitimacy of the Jewish state is not the discussion, that the normalization of Israel amongst others has always as well some counterparts, some duties as well. And I think that Israel should look at this jurisdiction, which is not as other jurisdictions, as one of the treasuries. Even though it's far from being perfect, it has to be completed, it has to be improved. The rules have to be more strict, more defined, more sophisticated. But it's definitely a treasury in the history of humanity, which owes a lot to the tragedy of the Jewish people. But at the end of the day, I would also ask the question to the Israelis. Could you accept that this number of civilian deaths is left without an inquiry? And if you are able to lead an independent inquiry, and I can tell you, I have no doubt about the independence of Israeli justice. I have no doubt about the integrity of the Israeli judiciary. And if I were the prosecutor of ICC, I would say to the Israeli, do this inquiry openly, yourself, visibly. If not, I would be obliged to do it for you.
Thank you very much. And thank you. The last point, raising complementarity, also can connect us to the next panel, because any investigation anyway would not apply to the issue of settlements. Israel would probably not investigate something that it doesn't consider as a war crime or as unlawful. So that brings us to the very heated also political issues on the table in the ICC potential investigation, or maybe not only potential anymore. And to talk about the geopolitical dimensions, I conclude. I thank our panelists and the participants. Thank you all, gentlemen, and let's move to the geopolitical dimension.